not only to those who are being considered to endorse. Fourth, the respondent in the impeachment complaint should have been given a chance to be heard on the articles of impeachment and the supporting evidence to prove the charges prior to its transmittal to the Senate, despite the number of endorsements from House members. The House of Representatives must be given reasonable time to reach their independent decision of whether they will endorse an impeachment complaint. The court, however, has the power to review whether this period is sufficient, but petitioner, who invokes the court's power to review, should prove that officials failed to perform their duties properly. Sixth, the basis of any charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. For the President and Vice President, these acts must be sufficiently grave, amounting to the crimes described in Article 11, Section 2, or a betrayal of public trust given by the majority of the electorate. For the other impeachable officers, the act must be sufficiently grave that they undermine and outweigh the respect for their constitutional independence and autonomy. And seventh, to ensure that respondent in the impeachment complaint is heard under the requirements of due process in the procedure under Article 11, Section 3, Paragraph 4, the House of Representatives is required to A. Provide a copy of the articles of impeachment and its accompanying evidence to the respondent to give him or her an opportunity to respond within a reasonable period to be determined by the House rules. The Constitution only requires an opportunity to be heard. It is up to the respondent to waive this fundamental right and opt to present his or her evidence at the Senate trial. And B. Make the articles of impeachment with its accompanying evidence and the comment of the respondent available to all members of the House of Representatives. It is the House, not 1/3 of the House, that has the sole prerogative to initiate impeachment complaints. Thus, there must be some modicum of deliberations so that each member representing their constituents can be heard and thus convince others of their position. The transmittal will only take place upon the qualified vote of 1/3 of the House. We quote from the final note of the unanimous decision. It is not our duty to favor any political result. Ours is to ensure that politics are framed within the rule of just law. We cannot concede the sobriety of fairness inherent in due process of law to the passions of a political moment. Our fundamental law is clear. The end does not justify the means. We understand our history. We have learned that in the past, momentary desires to do what is convenient and concede means to ends have inadvertently created precedents that weaken the succor of law for those who dissent, or those at our society's margins, or those who may have fallen out of grace from the powers that be. We have learned that the clash of political interests in the past, often disguised by noble intentions, has obscured the need to address the real problems of corruption, inequality, poverty, and disempowerment faced by our people. We will not allow that to happen again. We will not hesitate to declare what is legal, just, and right for our people. There is a right way to do the right thing at the right time. This is what the rule of just law means. This is what fairness or due process of law means, even for impeachment. End of quote. The Supreme Court's ruling is immediately executory. It shall be deemed served on the petitioners and released upon publication in the Supreme Court website and receipt of the parties of their digital copy in accordance with the guidelines on the transition to electronic filing in the Supreme Court. We urge everyone to read the full text of the decision and the concurring opinions. Thank you very much.